Hi, and welcome to the Siegfried Rivera 2024-2025 Legal Update. I'm joined with my partner, Jonathan M. Mofsky. My name is Roberto Blanch, and I'm also a shareholder at the law firm of Siegfried Rivera. Together, we're going to present to you the various bills that were enacted by the legislature during the last legislative session with effective dates that scatter throughout 2024. Jonathan?
Thank you. The legislation passed has impacted numerous sections of both the Florida Homeowners Association Act as well as the Condominium Association Act, in addition to the professional practice standards of community association managers as well as management firms and their operations. And so for that reason, because of the volume of changes throughout the legislation, we will cover what we believe to be the most impactful portions in this presentation. There are various other important aspects that directors, boards, managers should know about, and we have included those in a detailed update prepared by our firm, which is available upon request and can be distributed. So when listening in today, please bear in mind that we're covering this in a more general overview sense, and therefore it should not be construed as legal advice, but take note of the portions that are of interest to you and or to your association. Contact your legal counsel for more detailed explanation on the impact and application of the legislation specific to your community. And we will get started right now with the first two slides, which deal primarily with, they deal with homeowners associations.
Thank you, Jonathan. So as Jonathan indicated, the first slide pertains to House Bill 293, which references hurricane protection in homeowner associations. We're going to find comparable provisions within Chapter 718 that have made their way into Chapter 718 in a different legislative bill or through the adoption of a different legislative bill. But House Bill 293 focuses on hurricane protection standards within homeowner associations. And this bill was adopted and became law with an effective date of May 28th, 2024. As indicated, the bill and the sections of the statutes that have been modified and implemented with regard to this bill focus on the hardening of homes through various aspects or building components that are referenced as hurricane protection, such as roofs, affixed or roll down storm shutters, impact windows or doors, polycarbonate panels, reinforced garage doors, erosion control, exterior fixed generators, and fuel storage tanks. And the idea is for homeowner associations to adopt, or the architectural review committees of homeowner associations to adopt standards and specifications pursuant to which homeowners within the community may rely upon when they are interested in the installation of or in the improvement of their homes to incorporate hurricane protection items, such as those which we described previously to be known as hurricane protection. And so the specifications that the legislative bill contemplates the homeowner association or the architectural review committee to adopt, the specifications may include color, style of products, and other aspects so that an association, should it desire, could maintain a certain standard of uniformity or architectural appearance or design, while also permitting or allowing owners to harden their homes through the installation of or through the replacement of many of these building components that have hurricane protection aspects to them. These specifications and the items that owners desire to install in order to harden their homes must comply with applicable building codes, and a homeowner association cannot reject a request by an owner to install or harden their home so long as their building components or what they choose to install within their homes complies with the hurricane shutter, or the traditionally hurricane shutter, but now that has been expanded to include all of these other types of building improvements, such as the fuel storage tanks, generators, reinforced garage doors, impact windows, you name it. An owner's desire to install any of these enumerated types of improvements cannot be denied, so long as what they choose to install or improve upon their home complies with the specification standards that are adopted by a homeowner association. So it's important when reviewing this for the board or the architectural review committee to work closely with association counsel, and in many regards, perhaps architects or engineers, to ensure that these improvements not only maintain certain appearance standards and aesthetic standards, but also serve to achieve and comply with the applicable building codes for those improvements. In the next bill, which is known as House Bill 59 and adopted by the legislature effective July 1st, 2024, we find expansion upon what HOAs need to do with regard to providing notice to unit owners and copies of covenants or rules to existing homeowners as well as new homeowners. And so there is a requirement, an affirmative requirement within the bill and the changes to the statutes resulting from the adoption of the bill, that by October 1st, 2024, the association distribute to all homeowners and members of the association a copy of the association's current rules and governing documents or covenants. There's also an obligation for homeowner associations to distribute the rules or covenants to all new owners of homes governed by the homeowner association. And whenever amendments are adopted to the rules or covenants, those also need to be sent by the association to all members of the association. There are provisions within the bill that provide the association with the ability to upload some of these documents onto the association's website and provide notice of that to the owners who have consented to receiving notice by electronic means. And then it should also be noted that while the statutes have been modified or amended to provide for this accommodation with regard to providing these notices to owners who have consented to receiving notification through electronic means, there may still be owners within the community that have not consented to receiving notice from the association through electronic means. And so as it pertains to those owners, you need to continue to rely upon the traditional means of sending notice, and that would mean typically by mail to the mailing address of record for those owners.
All right, so we're going to turn to a condominium association slide now. We first heard from Robbie on HB 293, which dealt with hardening of homes and homeowners associations. Now we're dealing with hardening of condominium association buildings with the My Safe Florida Condominium Pilot Program. This is a program that is being developed and administered by the Florida Department of Financial Services. To apply for the inspection, it's fairly easy, as you can see from the first note on this slide, which is it just requires approval of a majority vote of the board or a majority vote of the voting interests, okay? And that's for the inspection itself. However, to apply for the grant itself to receive funding, the association has to receive all votes of all unit owners. That is a unanimous approval of all unit owners within the structure or building subject to the mitigation grant, okay? So it's a heightened approval requirement of 100% approval of the owners and the structure of the building. That's subject to the grant. That, for obvious reasons, that poses some practical considerations. I'm told that this is an aspect that may be revisited in the next legislative session, but stay tuned, we will see. The Department of Financial Services is in the process of developing the applications, the forms, and procedures for applying for the inspection and grants. That has not been released. None of that information really has been released yet by the department, and we're actively checking to determine the status of that. The grants are offered to the association itself, not to individual owners. And it's premature to go out and seek a vote of the owners at this point in time for the grant, because when voting, the legislation actually requires that disclosures be submitted to the unit owners when or prior to the voting for the grant. So those disclosures haven't been released yet by the department, and when they are, then votes can ensue and applications can be submitted. The mitigations, improvements that are to be completed as part of the grant have to be done within 1 year of grant approval. There's a process, or there will be a process, for seeking an extension, and the exception is if there's an extension granted by the department. And the last point on this slide is that it's a maximum of $175,000 per association for the grant, and that's the most that an association can obtain. All right. The next slide deals with continuing education requirements. This new legislation is in SB 382, and it does primarily two things. The first is that it authorizes distance learning to satisfy the continuing education requirements, as opposed to the traditional classroom learning. And I think more importantly, what it does is it creates an exemption for community association managers' continuing education requirements, provided that the community association manager meets three, prongs, right? The first one is that the manager holds an active license issued in the profession, okay? The second is that it's continuously held for at least 10 years. And then the third is that there's no disciplinary action imposed on the community association's manager. So that's a significant change for continuing educational requirements, creating that exception. We'll now move to the omnibus bill of 1029, where Roberto can get started with that.
Yeah, omnibus for sure. I mean, this bill is a very comprehensive bill. I believe.
I apologize to interrupt. I said 1029. I meant 1021.
1021, the bill that modifies numerous aspects pertaining to Chapter 718 and Chapter 719. As previously indicated by Jonathan, it's important to note that this is an extremely cursory review of what is about 154 pages worth of changes made to various statutory provisions governing condominium and cooperative associations throughout the state of Florida. And so by no means is this presentation intended to serve as a comprehensive review of every particular change. But with that in mind, we do also want to signal that there's more to come. Legislatively, we can anticipate that there might be additional changes. In fact, as we sit here today, there have been rumors of a special session being formed of the legislature with regard to further elaborating on some changes to the statutes, some of which resulted from this bill. So keep an eye out, keep your ears peeled, and let's see what transpires. But in the meantime, House Bill 1021, known as the Condo 3.0 bill, in some circles, did have an effective date of July 1st, 2024, and does rely on providing greater accountability with regard to board members and community association managers, and further seeks to expand upon the jurisdiction and scope of authority of the Department of Business Professional Regulation Division of Condominium, which has oversight of many of the issues that arise with regard to condominium associations and co-ops, and for many years has been cited to have little authority or jurisdiction with regard to the governance of condominium and cooperative associations. And so in the first slide, we touch upon some of the issues that you can now understand the legislature aimed to expand the authority and governance of the Division of Condominiums, Timeshares, and Mobile Homes, which is a division of the Department of Business and Professional Regulation. So we might interchangeably refer to the DBPR and the division, but they are a body of or an agency of the state of Florida, and do currently have traditional and now through this bill expanded authority over condominium associations and cooperatives. And so the first point is a clarification within the statute as to the expansion and jurisdiction of the division with regard to condo associations post-turnover, providing investigative powers to the associations with regard to records relating to financial issues, the conduct of meetings, conflicts of interest, elections and recalls, and also providing some authority with regard to an association's failure to respond with regard to written inquiries from owners, as well as the use of debit cards for unallowed or unintended purposes. This, again, is just a sprinkling of some of the expanded authority or jurisdiction of the Division of Condominium. There is a requirement for the division employees to refer theft, embezzlement, or other criminal activity of which they become aware to law enforcement agencies. And so no longer can the division employees or division representatives remain idle or silent in the event of having discovered some criminal action or activity within community association, as has happened on occasion when they are investigating some of the complaints that may have been submitted to the division for review by owners within the communities governed by those associations. The division also now obtains power to attend any association board of administration or unit owner meeting that is open to the members. So by virtue of the meeting being open to association members, and this would apply to board of directors meetings as well as condominium association membership meetings, think of the division as having an open invitation to attend those meetings should any representative of the division desire to attend that meeting. As we are aware that there has been the establishment or the requirement of the structural integrity reserves studies, and there are deadlines by which associations must comply with the completion of structural integrity reserve studies, the division is obligated to provide a database on its website for condo and co-op associations that have completed their structural integrity reserve studies, and that needs to be done by January 1, 2025. So there is a centralized place at which an owner or an interested party can identify or verify whether a particular association has complied with its obligation to complete the structural integrity reserve study. The division also now will have power to request access to an association's website with regard to responding to records requests. And the secretary of the DBPR, as distinguished from the governor, is now the individual with power to appoint the condominium ombudsman, a position that until the adoption of this legislative bill was a role reserved for the governor. Now, as previously indicated, the provisions enacted through House Bill 1021 seek to provide greater accountability to various association stakeholders. In this slide, we review some of the changes made or applicable to community association managers and providing a greater sense of accountability with regard to the activities of CAMs in connection with the operation or management of condominiums and co-ops. And the first of these is a requirement to provide or return to associations official records within 20 business days of a management company's cessation or termination of services to the association. As we know, many community associations rely upon their property managers to maintain the association's records, and within the course of its operations and management of the association, the community association management entity will retain or possess the association's records. And so upon termination or completion of its services for the association, the CAM is responsible and obligated by law now to provide or return those records back to the association within 20 days. And its failure to do so may result in suspension of the license, of the CAM license, and perhaps a civil penalty of about $1,000 per day up to 10 days. So failing to return records to an association in a timely manner can prove to be costly to CAMs. Again, seeking to provide a greater sense of accountability on the part of CAMs to associations. Additionally, we also see the need for community association managers and management firms to disclose to the associations and its board whenever there is a conflict of interest. There have been numerous instances in which a community association management firm or a community association manager may either have affiliated entities, or there may be a relative of a community association manager or the owner of a community association management firm that may have a business or may be in business with someone else and provides or seeks to provide services to the association managed by that property management firm. And so there is this desire, again, to disclose these inherent or possible conflicts of interest to the boards of directors, and through the boards of directors and through the disclosure, also make it known to the community association membership at large that there are these possible conflicts of interest that are being sought to be introduced into the association. It's not to suggest that you cannot hire a relative or an affiliated entity, but rather these statutes aim to provide greater clarity and transparency with regard to these potential conflicts of interest by means of disclosures to the association and its membership of potential contracts that exceed $2,500 for services sought to be bid upon by whether it is a relative or an affiliated entity of a property management firm. And the disclosure needs to be brought to the board's attention and placed on the association's agenda, and the agreement pursuant to which those services, those affiliated entity or related party services are going to be provided to the association. Not only do they need to be included on the agenda of the board meeting at which the disclosure is being made, but the contract also needs to be included together with the notice and agenda for that meeting. It's important that in the event that these required disclosures are not made and that the conflict is not disclosed to the association, then by vote of 20% of the community association's membership, those contracts that an association entered into with a community association manager's related party or affiliated entity or relative, those parties are subject to being void or terminated by vote of 20% of the association's members whenever the necessary or proper disclosures are not made. So again, seeking or aiming by virtue of this legislation to provide greater accountability and also greater consequences to managers in the event of non-compliance with these requirements. We also notice in the next slide the expansion of what we've seen over the past few years and previous legislative sessions of making certain offensive conduct or offensive actions criminal. And so we had first seen that the inclusion of the definition of kickback in the statutes many years ago, and then we saw the legislature create certain statutory provisions to criminalize some of this conduct, and so now there continues to be a trend to making a lot of these offensive actions or criminal conduct a more harsh penalty to those parties that aim to violate these provisions. And we see they are, common sense provisions here that make their way into the statutes. And so, for example, should a director or a community association manager that knowingly accepts or solicits a kickback, that person commits a third-degree felony and is subject to a civil penalty, must be removed from office, and in the event they are removed from office, a vacancy on the board must be declared as a result of that individual's removal from office if we're talking about a director. Any person who knowingly or intentionally destroys or defaces association accounting records or fails to maintain or create accounting records required to be maintained by the association is subject to civil penalty and must be removed from office and vacancy. And again, this one and the next bullet point were responses by the legislature to address what had been allegations by many association owners that managers or directors or officers had an incentive in some cases to hide their wrongdoing by either destroying or not making association official records accessible. And so in the third bullet point, a person who willfully or knowingly refuses to release or produce association records with the intent to avoid or escape detection, arrest, or trial, or punishment for the commission of a crime, or to assist another person with such avoidance or escape, is committing a felony of the third degree and must be removed from office and a vacancy declared as a result of that removal from office. And the last bullet point is that the establishment or creation of new statutory provisions regarding fraudulent election voting activities. And again, this is aimed to deter those individuals that may have sought to tamper with the election process with the objective of influencing the results of that election or in frustrating the ability of association members to effectively achieve an election for the association's board of directors. Next, and also as a result of House Bill 1021, we find that there were some changes enacted aimed at the association's official records and providing greater clarity or transparency with regard to the availability of association records. And in so doing, we find that invoices, receipts, deposit slips, payment records, building permits, and board member evaluation certificates have been added to the enumerated list of items that must be maintained as association official records by an association, and also allowing associations to satisfy records requests by making association official records available for download on the association's website or through a mobile application. Until now, an association had been required to maintain numerous association official records on its website, but was also, notwithstanding the inclusion of those records on the association's website, the association was nonetheless required to provide physical access to those records at a unit owner's request to inspect such records. Well, now, as a result of these changes enacted through House Bill 1021, an association may satisfy its obligation to make records available to a unit owner by having those records available for download on the association's website or mobile app. There's a provision for good faith obligation for associations to maintain and or recover records that are absent from inventory, recognizing that from time to time an association's records either may be lost or unavailable throughout the years. And so the bill does provide for the ability of an association to recover these records. And in an effort to maintain accountability with regard to records being produced to unit owners making requests for the inspection of records, an association is now obligated to provide a checklist to the unit owner when they are performing the review of the requested official records. And this checklist creates a rebuttable presumption that the association has complied with the owner's request to review the records listed on the checklist. And these checklists must be retained for 7 years by an association as evidence of its compliance with the obligation to make records available for inspection. Effective January 1st, 2026, and this is very important for associations to know, the number of units that an association has which requires the association to have a website has been reduced from 50 units to 25 units. And as a result, condominium associations with 25 units or more are now obligated to have a website. That number prior to this legislation was set at 50. Continuing on with changes resulting from House Bill 1021 that are applicable to the operation of associations, of condominium associations, we find that condo associations that have more than 10 units must hold board meetings at least once a quarter. And unit owners must be allowed to ask questions. Unit owners in attendance at those meetings must be allowed to ask questions with regard to the status of construction and repair projects, revenues and expenses for the current fiscal year, and other issues affecting the condominium. Again, this for most associations really shouldn't be an issue because in my practice, I have come to find out that condominium associations do have meetings more regularly than quarter, but suffice it to say that there was no affirmative obligation for a condominium association board to have at least one meeting per quarter, and that now is an obligation. So we do need to be mindful of that, especially for those association boards that might take a break or a hiatus over the summer months. The next provision is that and we talked about this previously as it pertained to homeowner associations, but we now find also an expansion upon the statutory provisions that require associations, condominium associations, to adopt hurricane protection specifications and provisions in all residential mixed-use condominiums, regardless as to the creation of those condominiums. Now, where we talk about these provisions that aim to provide or apply rather to all condominiums, irrespective of when the condominiums were created, we do want to provide a caveat that more and more and more and more we see arbitrators and courts referencing the Kaufman language and the provision of Kaufman language, and whether or not some of these legislative changes apply or don't apply to condominium associations that may not have Kaufman language in their declarations of condominium. And so while there is an effort in the legislation, and while the legislation does aim to provide language seeking to make these statutory provisions applicable to all condos, we do want to caveat that should your association's governing documents, should your declaration of condominium, for instance, not have what is known as Kaufman language, then you should consult with your association legal counsel in order to find out the extent to which a lot of these updated legislative provisions may or may not apply to your association. But with that in mind, and as it pertains to hurricane protection, there is a requirement for recording of certificates attesting to votes taken by associations to mandate hurricane protection, such as hurricane impact windows and doors within a building. Those types of votes need to be evidenced vis-a-vis a certificate recorded with the public, with the public records of the county in which the condominium is located. There's also now allowing for the boards to require unit owners to adhere to an existing unified building scheme with regard to the external appearance of a condominium. And so, again, as within the HOA setting, an owner is allowed to install hurricane protection protecting their units, so long as it complies with the specifications adopted by the association's board and applicable building code. And in adopting these specifications, condominium association boards are allowed to preserve uniformity or a unified building scheme as to the external appearance of their building. House Bill 1021 also introduced language providing that a unit owner is not responsible for the cost of any removal or reinstallation of hurricane protection if the removal was necessary for the maintenance, repair, or replacement of association property. Very often we find that condo associations need to have either hurricane shutters or windows or sliders that might be impact rated removed in an effort to perform work to the common elements or the building structural elements. And in so doing, the cost of the removal and reinstallation of that protection seems now to be the responsibility of the association and not unit owners. And again, this is a very important provision for many community association boards to keep in mind, and property managers, because it is a departure from what has historically been the application or the norm as to cost allocation for the reinstallation of some of this hurricane protection. Owners who opt in to electronic voting must be permitted to vote electronically in subsequent elections. So keep in mind that we had historically said that if you opted into electronic voting, there was no obligation on the association to make electronic voting a requirement for all subsequent unit owner meetings and all subsequent elections. Well, as it pertains to elections, this seems to no longer be the case, and therefore, if electronic voting has been established in your community and your condominium association, and an owner has opted in to electronic voting, then that owner must be permitted to vote electronically in all subsequent elections. In the next slide, again, continuing with the changes that are applicable to operation of condominium associations and co-ops, we find that should there be a desire to suspend voting rights with regard to delinquencies of owners, then prior to the election, 90 days prior to the election, those owners that are delinquent must be notified of their delinquency and the desired suspension of voting rights. With regard to the common elements of a condominium that is created within a portion of a building or a multiple parcel building, the declaration of that condominium must specify the party or parties that are responsible for maintaining and operating those portions of the building which are considered to be shared facilities. This is typical within what is known as mixed-use condominiums or condominiums in mixed-use buildings, where you might have different types of ownership structures such as hotels or office spaces or retail spaces or commercial spaces. And so within these condominiums that are created or established within buildings that are shared with other buildings or within multiple buildings, we do need to be mindful of the fact that those declarations must establish which party is responsible for the maintenance and operation of the portions of the building known to be shared facilities. And last but not least, with regard to House Bill 1021 and the changes resulting from House Bill 1021, we now discuss the expanded educational requirements for certification of board members. And whereas before a board member had the option of either signing a certificate within 90 days of having been elected or appointed to the board or taking a board certification class, now the statute requires an initial session of 4 hours as mandatory, with yearly 1-hour updates required for all board members, as well as having to sign the certificate, written certification. This signed written certificate, as well as a certificate that the board member has complied with the educational course requirements, must be maintained by an association for 7 years, and the director must annually certify, or the association must annually certify that all directors have complied with the educational requirements imposed by the statute, and the directors elected or appointed before July 1st, 2024, which was the effective date of House Bill 1021, they must comply with the new certification class requirements by June 30th of 2025. So this wraps up our review, very cursory, I'd like to say, very cursory review of the comprehensive changes made vis-a-vis House Bill 1021, governing primarily condominium and cooperative associations.
All right. So similar to 1021, which governs condominium associations, we have House Bill 1203 addressing homeowners associations, but less daunting than 1021. It covers various areas of the Homeowners Association Act, as well as community association managers and professional practice standards, where it touches on changes to record keeping, financials, areas such as official records requests, education requirements, and transparency. So the first slide we're getting to deals primarily with the idea of community association managers having to be involved, knowing who they are as to the specific community, and readily available or easy to locate. So the first point we have on the slide is that now there's a mandatory obligation through this statutory legislation that the manager attend in person at least one member or board meeting per year. So that's either a membership meeting, such as the annual meeting, right, or a board meeting per year. There's also an obligation on the community association manager or management firm to provide the homeowner association members with the name and contact information of each manager or representative of the management firm assigned to the community. Okay, the manager or representative's hours of availability for the community, and a summary of the responsibilities, duties, or obligations for which the manager or representative is responsible. So those are all obligations that are now required through this statutory amendment. In addition, if requested by a member, a copy of the contract with the homeowners association and the management company must be made available to the member. Obviously, that contract is an official record of the association and must be maintained by the homeowners association in accordance with the official records requirements. Touching on education requirements, we have now an obligation for a minimum of 5 hours of education specific to homeowners associations now to be completed biennially or every 2 years by the association managers for homeowners associations. And emphasizing the importance of record keeping or official records, the legislation includes a requirement that 3 hours of that 5 hours of education must be specific to record keeping. So we're now sort of shifting toward becoming a little bit more consistent with condominium associations here. And as Roberto discussed in 1021, some website requirements, homeowners associations now must, and that is for homeowners associations with 100 or more parcels, maintain a website which will include the posting or availability on the website or a link, the statutory list of official records, okay? There is a list, become familiar with it, make sure that your website is compliant and includes all items on that statutory list. I'm not going to include them all here, but they include everything from contracts to board meeting notices, financial records, and beyond. There's now an obligation for homeowners associations to provide access to law enforcement within 5 days of receipt of a subpoena, the documents that are being requested, all right? So we have to provide documents to law enforcement within 5 days of the subpoena, of receipt of the subpoena, unless there's a longer time that's been extended to the association. In addition to that, there's now an affirmative obligation on the homeowners association to assist law enforcement, okay, in the investigation to the extent that it is permissible by law. So what that means, we don't exactly know, and how it will be used, unclear, but it's broadly worded. The only caveat is if the assisting of law enforcement would not be permissible by law, all right, then the HOA, homeowners association, would have an out. But in all other situations now, homeowners associations have an obligation to aid law enforcement in any investigation. HOAs with 1,000 or more parcels must now prepare audited financial statements regardless of the annual revenue. It used to be that it was only for audited statements if the revenues were 500,000 or more. Now there's also this requirement which doesn't focus on what the revenue amount is, but rather focuses on the size of the community in terms of parcels. All right, so it doesn't refer to members. Obviously, this is specific to 1,000 parcels or more. And there is added in a prohibition on the use of debit cards for homeowners associations. This is an important one. It also goes beyond the simple prohibition on using debit cards, and the legislation touches on if it turns out that a debit card is used for something other than a lawful obligation of the association, then the statutory language, imposes a finding that it's theft. It's considered theft and a crime under the law. And so lawful obligation means, under the law, any properly pre-approved expense by the board that has been detailed in the minutes or something that's in the written budget. But in all situations, we shouldn't get to that point because debit cards have been prohibited and may not be used by homeowners associations now. The next slide deals primarily with education requirements and certification of directors in homeowners associations. Now we have a written certification form that must be submitted attesting to or showing, evidencing that the director has completed a division-approved education course within 90 days of being appointed or elected. All right, the education curriculum covers items or must cover items, including financial literacy and transparency, record keeping, the levying of fines, and meeting notice requirements for the association. 8 hours of that education annually must be completed for directors with more than 2,500 parcels, and it's a 4-hour requirement annually for directors governing communities with less than 2,500. The certification is valid for up to 4 years, after which a director will have to then resubmit and attend another course through the division approved or meeting the division approved requirements. Touching on criminal offenses, we now have legislative change adding that if a director is charged or through information or indictment with a crime, that a vacancy is created for that director's seat. And the director is removed from the board. And that goes to a charge, not a finding of guilt or innocence, but any charge on the director. The director seat is now vacant. We have accounting responsibilities and a requirement to provide an accounting to owners when requested. That deadline is within 15 business days of the receipt of the request. It's important to comply because the statute also now imposes the possibility of a waiver of any fines on the account due to non-compliance. We have prohibitions on certain restrictions, right? So the legislature has determined that for homes where changes are made to the interior of the structure that are not visible from the outside, from an adjacent property, from the frontage of the property, we cannot now place restrictions regulating those interior changes. Similarly, the homeowners association or architectural review committee would not be able to restrict or deny HVAC systems from being installed where the HVAC systems are consistent with or meet established guidelines by the ARC committee or the homeowners association. And I think the most important takeaway from this slide is now the requirement that if the homeowners association or the architectural review committee is going to disapprove of a request, that it must be done in writing. And it must be specific in two regards. The first is citing to the specific rule or restriction upon which the denial is based, okay? And the second is the specific reason why, or the specific part of the proposed improvement or change that does not conform or comply with the rule. And obviously that's for transparency reasons. Adding to that, I think it becomes very important for associations to maybe revisit their rules to make sure they are clear and as specific and detailed as they would like, so that when it comes time to issue a disapproval or rejection of an application request or modification, that the association can state with certainty why it doesn't conform to the rule. This slide deals mainly with what HOAs cannot do anymore, okay? And it expands on the list of what homeowners associations are prohibiting from preventing an owner from displaying. I think it was in last legislative session, we saw it was boats that weren't visible from the outside, and now it's vegetable gardens and clotheslines that were added to the legislation. So we're just expanding on those items and making the reach and regulation of the homeowners association a little bit less. Similarly, homeowners associations can now not prohibit the parking of personal vehicles, including pickup trucks, in the driveway or other parking area. Cannot prohibit owners, tenants, guests, or invitees from bringing or parking a work vehicle, which is not a commercial motor vehicle, in the community, regardless of visible insignia or designation on that truck. The commercial vehicle designation now is defined by statute in the legislation. So, this will raise, and the other issues I addressed and to be addressed in this legislation will raise certain issues as to what an association's existing covenants provide for, and then reviewing those covenants in conjunction with this new legislation to determine interpretation. There's also some question, similar to what Roberto pointed out, as to Kaufman language, or whether some of these statutory changes will impact an existing set of covenants and restrictions for a homeowners association at all, where a homeowners association has the existing criteria or regulations set forth in its declaration prior to the enactment of these legislative changes. Those issues will all need to be reviewed on a case-specific basis. But in general, what we're discussing here are the broad obligations that are set forth and the broad restrictions that are set forth in the Homeowners Association Act now as to all associations. Cannot deny a homeowner's selection of a contractor or service provider that wants access to the homeowners association community now, including denial for not providing a proof of professional or occupational license. And also, we cannot now prohibit owners or invitees from parking first responder vehicles on the property. Again, homeowners associations as opposed to condominium associations, for obvious reasons. We're dealing with homeowners associations that may have different types of roadways, may have swale areas, may have various parking areas. And this slide's generally addressing fining, okay? The first point of this is dealing with what we cannot now fine for, all right? And so where the garbage receptacle is left out within 24 hours before or after the designated garbage day, there can be no issuance of a fine for such a violation. And similarly, if a homeowner has left out the holiday lights or decorations beyond the time frame set forth in the restrictions, then fining cannot be provided for by the association, except if it extends beyond 1 week after the association provides written notice of that violation to the homeowner. So keep note of that, maybe not necessary to amend your rules specifically as to that point, but important to keep in mind in terms of enforcing your rules. There's also been some changes as to the new procedure for fining for homeowners associations. We're going to cover the general list here, but for those homeowners associations which do implement fining or the suspension of use rights, I think it's very important for you to seek specific guidance as to how these changes will impact your fining and or suspension process for your community from your legal counsel. The first is that the homeowners association has to provide 14 days written notice of the right to attend a hearing. Right? The statute previously didn't include the written notice requirement. Now it does for clarification. The hearing must be held within 90 days of that written notice. So what was seen previously is that the notice was sent out, the hearing was canceled, or, and it was later postponed, and maybe there wasn't a new notice that was sent, or maybe the notice provided for the hearing to occur in a period later than 90 days. Well, now that cannot happen. It has to happen within 90 days of the written notice. The specific finding, of the committee has to be confirmed within 7 days after the hearing occurs. It has to be submitted in writing to the person sought to be fined, so it cannot occur later than that. And it must also include, I guess a separate notice could be provided, but typically it would be included in the finding of the committee, what the instructions for payment of the fine or compliance with the suspension of use rights would be. So there can be an opportunity to cure or an opportunity to come into compliance. How that applies to violations that may arise which are beyond cure, for example, where the dog improperly is off leash, and in the future, that's an incident. You can't cure that incident from occurring. But in the future, the owner could refrain from engaging in that type of violation in the future, is something that should be discussed with legal counsel, because the notice to the homeowner should be specifically prepared as to the homeowner's responsibility to pay the amount of the fine and or, as applicable, cure the violation or remedy the violation so as to not have to pay the fine or not incur the suspension of use rights. The association cannot require payment of a fine less than 30 days notice from when the fine was approved now. All right, so it used to be the case that the letter would go out and the homeowners association would request payment within 5 or 10 days. Now it's a minimum period of 30 days. And that date is now determined by the committee as well, whereas previously management and or the board may have determined the date. It's the grievance or other committee established for fining that would determine that date. And if the homeowner fails to comply with the notice of fine or to cure the violation, then the statute has been amended to provide for an award of reasonable attorney's fees and costs to the homeowners association. So that generally concludes the subject of fining for homeowners association. Again, I think it is more detailed than what we've discussed here, and I think it's important for the homeowners association to not only consider what the legislation provides and how that impacts what the association will be doing in the future for fining and or suspending, but for the association to look carefully at what its specific covenants provide for, so that the homeowners association is complying with the appropriate process for fining in the community. That concludes our presentation. We appreciate everybody's involvement and participation.
Yeah, it's a wrap. If we can understand that many of you might have questions or would like for us to elaborate perhaps on how some of this may impact your community specifically. And as a result, both Jonathan and I have put our contact information on this slide. You could contact either one of us at your discretion, at your desire. And we've also got our main number here for the office and for our website, at which you can visit our website and find plenty of information about our firm, as well as other resources that we offer on our website, such as archived articles and other informative information. We appreciate you tuning in and also are thankful for your attention to this presentation. Look forward to seeing you on the next one. Thank you so much.